Welcome to today's video, where we examine 3 sovereign citizen courtroom appearances. We begin in Kansas, where a defendant rapidly loses the benefit of a PR bond after his conduct changes the judge's perspective. We then move to Michigan, where 2 judges directly confront and decisively reject sovereign citizen arguments grounded in fundamental misunderstandings of the law. The final segment serves as a lead-in to a case previously covered on this channel. Let's get started.
All right, I think that takes care of the jail. The other one is appearing by Zoom remotely on her own. She was summoned to appear, and she has appeared on a summons. Michaela, it looks like we got you served in Wichita. It looks like there is a September battery charge, theft charge that got filed. And that's why you're notified to appear today. It's alleged that you had physical contact with Lori Jasso, Jasso. They call it done in a rude, insulting, or angry manner. So usually it's hitting, shoving, pushing, something of that nature, part of a fight or disagreement or out of anger. It is a B-person misdemeanor if convicted of battering someone. Maximum 6 months, $1,000 fine if convicted. And then it's also alleged that you took her purse and her cell phone and some stuff in her purse without her permission. The value less than $1,500, which also makes it a misdemeanor. It's a Class A non-person. It's always interesting that property crimes are a higher classification than person crimes, like a battery, but that's how it's set out legislatively. The maximum sentence is 1 year in the county jail and $2,500 fine if convicted. I'm going to enter a not guilty plea for you. If you're employed, I'm going to ask that you make an effort to retain your own attorney. If you're not employed and you have dependents that you support, then I will appoint an attorney to represent you. You will need to go before our magistrate judge on January 26th. The time depends on whether or not you get a court-appointed attorney or you hire your own. But the date's the same in front of Judge Webster. I'm going to allow you to sign your own bond since you were brought in on summons and you voluntarily appeared. You'll need to make arrangements to sign a $2,500 bond, which means if you don't show up for your court appearances, we can take a judgment of $2,500 against you, issue a warrant. It's added to your court costs in your case. And then probably a bondsman will have to get involved, and you'll have a higher bond that'll be set for your future appearances. So that's kind of how a signature bond works.
A signature bond, also known as a PR, personal recognizance, or OR bond, allows a defendant to remain free while awaiting trial based solely on their promise to comply with court conditions. However, this privilege is not guaranteed. The court may revoke the bond at any time, especially if the defendant makes harmful, reckless, or inappropriate statements on the record. Exactly what unfolds next.
I am here as the representative of the entity that you speak of, but I'm the living woman and I do not consent to these proceedings. So, and also and for the record, I have the right I have the right to face my accuser. And they have to be a living man or woman. So as far as that matter goes, I move to dismiss the matter entirely.
Okay. Well, I move to order you to appear on Friday at 1:30 at the courthouse in front of myself, no matter what your name is or your affiliation. And to bring with you anyone that you are an agent of or you represent. If you don't appear, I'll issue a warrant for your arrest or for her arrest.
Your Honor, are you setting the $2,500 OR bond?
No, I'm not.
Okay.
No, I've got to see her face to face, and get her identifiers and have you personally appear, and that's going to need to be in person here at the courthouse in my courtroom.
What was the date and the time for that, ma'am?
Friday at 1:30, courtroom A in El Dorado at 201 West Pine. And, I think that makes that the 14th at 1:30, please. Okay, I appreciate it. If there's nothing further today, though, we'll adjourn on this case. We won't proceed any further.
That may set a record for the speed at which a PR bond was modified. In a matter of sentences, the judge revoked the signature bond and ordered a formal appearance bond instead. We then turn to Michigan, where sovereign citizen Timothy Michael Keynes makes his first in-custody appearance before Judge McNally, widely regarded as one of the most no-nonsense judges on the bench.
All right. Keynes, Timothy Neal Keynes, 23R513178.
Good.
Go ahead.
Okay, good morning, Your Honor. Alex Green IV, PA 2657, appearing on behalf of Timothy Michael Keynes, who's zooming in from the Wayne County Jail.
Did you talk to the prosecutor about this one?
I did not, because I have noticed that my client wishes to get some discovery, and I didn't see anything to file.
Okay. All right, Mr. Keynes, your name?
Timothy Keynes.
How long are you in custody there for on other cases?
I have no clue. I'm waiting for my tether. This is holding me up for my tether. So I asked for a discovery for this case.
Yeah, I don't have a problem. I hate to see you sitting in there all day. It's too bad you didn't show up for several days. It's too bad you didn't show up when you were supposed to. Give me a new date on the Rockwood case, Lisa.
Judge, I just want to be sure what we're doing here, because if we do discovery,
Pull him up.
this Mr. Green won't be here.
It's going to go back to
Except for a pre-trial today.
Right. It's going to go back to Mr. Gaith.
Okay, should we just have Mr. Gates talk to him today? It's on the docket for a pre-trial. I don't know if they realize that.
I think Mr. Green did, and his client wants discovery.
Yep. Of everything.
That's fine, Mr. Keynes. You don't have to.
Well, I mean, it's not no one else's freedom.
July 10th, 8:30.
Well, I don't know what you mean by that. We're trying to accommodate you here. I don't have any problem with you adjourning it.
Thank you.
Do you have other holds?
No, but this case out of, I think it was Taylor.
Okay.
And so that was a possession of some type of drug paraphernalia or something like that. I'm sure he missed a couple of court dates on that. And then on in this case that he has a posted of $250, $2,500, 10%.
That he hasn't posted.
Yes.
Right. Because he didn't show up on this one either.
I didn't have that.
Yeah, he was supposed to be here in 2023. What is all this yellow stuff all over this docket? Lisa? My grandkids got the crayons out. And do you have any idea?
These deficiencies were not the result of amateur drafting, but rather of incoherent and careless filings submitted immediately following the motions.
On the file?
Anyway, July 10th at 8:30. Good luck, Mr. Keynes. We'll see you here then, okay?
Yep. Thank you.
Right.
Okay, thank you, Your Honor.
So I stay here for another 10 days.
I'm not letting you out. You didn't show up here for 2 years.
The papers went to my house and my mom's
Listen.
house when I lived in Taylor.
No. I'm not lowering your bond. I'm not giving you a personal bond. You've been playing with us. Okay? No. That's why I was questioning why you wanted to adjourn it, because you're not, unless you can post a bond, you're going to be sitting there. And I don't know how else to put
I'm
it.
suing those cops.
I'm sorry?
I'm suing those cops. This is horseshit.
Go ahead. Show up in court. You would have had your day in court. You'd have been acquitted 2 years ago. I'm not going to go on that. I could care less if you sue. Go sue whoever you want. Sue me if you want. Show up in court. Good luck. If you want to do something else, I'll be glad to get the police report from Rockwood and go talk to him some more. I don't have any problem with that.
No, I think that the major issue was you were looking for, and I did explain that there no guarantee of a personal bond because he hasn't been missed in court case.
And he missed not only this, he missed Taylor too.
Right.
So this is not an anomaly. He checked something here. You know, it never fails. It never ceases to amaze me. Okay? He's got it worn out of Hazel Park, worn out of Southgate.
I had time for Hazel Park.
Bonia, worn out of Taylor, another 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 one out of Taylor. He doesn't show up on this for 2 years and he wants to talk to me about suing cops. Do whatever you got to do. I don't know who you think you are. You must be running the Pentagon at least. Shut him off, Lisa. We'll see you here in a couple of weeks. I'm not going to listen to this nonsense.
All right.
Thanks.
Thank you.
Concludes the first hearing, though it will not be his final court appearance. While a July 11th hearing did take place and was not uploaded to YouTube, he appeared again approximately 1 month ago before Judge Shackelford. That proceeding is publicly available.
All right, this is the People versus Timothy Keynes. Mr. Keynes, if you can come on up. This is 230605, 230604, 230603, and 230602.
Good afternoon, Your Honor. James Gazicki on behalf of Mr. Kane. Mr. Kane is requesting a jury trial. And just for the record, I explained this to Mr. Kane that he's a sovereign citizen and I am not familiar, nor do I practice any laws regarding.
Because there aren't any laws regarding them, Mr. Gazicki.
Exactly, Your Honor. And I explained to him that I would represent him under the laws of the state of Michigan.
We will set a jury trial date for March 13th of 2026. You'll be required to appear in person that date. And the trial starts at 9 a.m. So you should be here no later than that. Okay? And sir, 1 second. Is there any potential that I should set a final settlement?
I would set a final settlement conference, Your Honor.
Okay. So we'll set one final settlement conference. All right, that's your jury trial day. We'll send you out notice in the mail of your final settlement conference as well as your jury trial date, okay?
All right, thank you.
All right, you're all set.
Have a good day.
That hearing was largely procedural, but I'm sharing it here for completeness. Jury trials are rarely streamed on YouTube. However, if one becomes available, I will cover it. Next, we turn to a sovereign citizen case from Colorado that I previously featured. While reviewing that video, I located an earlier hearing it referenced, one in which the court rejected the defendant's so-called right to travel argument. If you haven't seen that hearing yet, you'll find a card above linking to it once this video ends.
Thank you. Area code 719, last 2 digits 64. Who might that be? Area code 719, last 2 digits. Oh, Mr. Shadowins. Thank you for appearing, Mr. Good morning, sir. For the record, this is 25T262, 25T448, 25M318. I do appreciate you appearing. I guess I could call all your cases. Looks like you also have 25M395, 25M375, 25M352. Okay, so actually, In 25T448, Mr. Shadowins, I do need to advise you of your rights and of the charges. You have the right to remain silent. That means that you do not have to make a statement about your charges to anyone. Anything that you do say concerning these charges can and may be used against you in a court of law. You have the right to counsel. The court recommends that you have an attorney represent you. You may be entitled to a court-appointed attorney. If you are indigent, you have the right to request the appointment of counsel or consult with a public defender before any further proceedings are held. You have the right to a trial on your charges. You can have that trial in front of a judge or jury. You have the right to know the nature of the charges against you, which we'll get to in just a moment. Any plea which you make to the charges must be voluntary and not the result of any undue influence, pressure, or coercion on the part of anyone. You have the right to bail if the offense is bailable and the right to know the amount of bail set by the court. As a general advisement, if you are not a citizen of the United States, whether or not you have lawful immigration status, you should tell your lawyer because you have the right to receive advice from your lawyer about the specific impact this case may have, if any, on your status. As a second general advisement, and I know this does apply to you, sir, if you are a current or former member of the U.S. Armed Forces, you may be entitled to receive mental health treatment, substance use disorder treatment, or other services. Do you understand your rights, sir?
Thank you, Your Honor.
Okay. I'm going to just advise you of the charges. There's first, failure to display proof of insurance, class 1 traffic misdemeanor, carrying possible penalties of 10 days to 1 year in the county jail and or a $500 to $1,000 fine, 4 points against your license. The second charge is driving under restraint, which is a class A traffic infraction, carrying fines up to $100. The third charge is having a fictitious registration plate, class 2 traffic misdemeanor, carrying possible penalties of 10 to 90 days in the county jail and or $150 to $300 fine. Finally, you're charged with having an unregistered vehicle, a class B traffic infraction, carrying fines up to $100. Do you understand the charges and possible penalties in that case?
Thank you, Your Honor. Is the court and the people aware of my notice for record of impossibility?
No idea what that means, sir.
I was informed, I'll clarify, Your Honor. I was informed by the court clerk that my notices for record of impossibility to meet statutory requirements such as a driver's license, insurance, and registration due to service-connected disabilities. I corrected my status in equity, and I'm not surety for any of that. I cannot get a driver's license. There is no legal recourse or remedy, ma'am. So I clearly stated I was traveling, which I believe is a fundamental right established and upheld by the U.S. Supreme Court. So I would motion at this time to dismiss for a lack of Sixth Amendment nature. Please.
And does not excuse the failure to obtain a valid driver's license, vehicle registration, or insurance. Absent compliance with these legal requirements, the defendant has no authority to operate a motor vehicle on public roadways, regardless of any claimed change in personal or legal status.
Mr. Parsons.
Your Honor.
You can just sit, that's fine.
The people are opposed to the pending defense motion to dismiss these cases. The stated reason is that the defendant cannot get a valid driver's license. The nature of the charges across all these cases go beyond just a no operator's license charge. My office has been in extensive communication with Mr. Shadowins. I'm aware that he is contesting these cases. I disagree with his argument regarding a right to travel as he has articulated it, and people are opposed to the motion to dismiss.
Thank you. The court will deny the motion, sir. Under case law, People v. Zen 843P, second 1351, the court held that the right to drive an automobile on public roads is not a fundamental right. The courts have long recognized the right of states to regulate the use of motor vehicles on roads within the state. So I deny your request to dismiss based on a right to travel. So are you,
Would the
Mr.
court
Shadowins,
please
were you in?
clarify the Sixth Amendment nature, please?
I'm not even sure what you mean by that, sir, but
Who is the
what is
injured
your
party,
argument?
ma'am? I'll clarify. Who is the injured party? I am not aware of a victim or damaged property. I'm
There's-
asking simply for clarity of the Sixth Amendment nature of, okay, and cause of any of these cases. Who is claiming injury?
Well, sir, as when you drive, driving is a privilege, and the legislature has imposed regulations on what you must do in order to drive on public roads. So I guess the injured party would be the state of Colorado. You are being, all these cases are named state of Colorado versus you. There are other cases where, in cases where you're alleged to have resisted arrest and harassed people, though there are actual victims in those cases. So obviously that argument does not hold water. So Mr.
Objection, Four
Shadowins.
Corners rule, please. Can we please stick to the one case at a time, please, ma'am? And so, thank you. I don't have a driver's license. There's no contract. How can I be charged for violating a contract I never acquiesced to or agreed to due to impossibility?
Even in the absence of a signed agreement, you implicitly entered into a social contract by choosing to operate a vehicle on public roadways. This decision subjects you to the laws and regulations established to ensure public safety and order.
Sir, that is not a persuasive argument. As I've already mentioned, I am bound by the law of the state of Colorado.
I'm asking a question. I'm not making an argument, ma'am. I'm not presenting an argument, ma'am. I ask a question. Please and thank you.
I'm sorry, sir, but your question is nonsensical. So I am already told you that it is that under Colorado case law and statute, you are required to have.
Can the state be an injured party, ma'am? Point of clarity, can the state be an injured party?
Yes. All right, so Mr.
It's a body politic, is it not?
Mr. Shadowins, I am not going to engage in these sovereign arguments with you right now. What I will tell you is, if you wish, we're going to give you another court date. I guess you've bonded out on, I guess, 3 of the cases recently. I mean, we can set them all over to December 1st at 8:30 if you'd like. Is it your intention to apply for a public defender or hire private counsel, or do you intend to represent yourself in all of the cases?
Sui juris, I have no choice but to represent myself. I haven't received much response from the people. I can't seem to get my questions answered. I actually was not arguing, ma'am. I'm just asking questions. So at this point, I will waive the court, request an Article 3 trial and discovery from the people, please, in all these matters, and we'll proceed by special appearance. Thank you.
Your Honor, if I may, these cases are not subject to Article 3 jurisdiction.
Are not subject to what? I'm sorry.
Article 3 jurisdiction under the federal constitution.
He's talking about the federal constitution, I know.
Your Honor, my office has been in communication with Mr. Shadowins about the process for how to request and pick up discovery. We have also communicated, obviously, the WebEx information, which I believe he's utilizing to appear in court today. He is welcome to continue those conversations with the district attorney's office, specifically Investigator Schaff, who has reached out to him about the discovery process.
Okay, so you'll get your discovery. So do you want me to set your cases for trial, sir, or do you want to make an effort to apply for a public defender or hire private counsel?
If the people are ready to proceed with trial?
Sir, I'm sure they will be whenever it's set, but it hasn't been set yet. So are you wanting to enter not guilty pleas on all cases? And I can give you what's called the Arguello advisement and give you jury trial and pretrial readiness dates. I guess I would recommend, Mr. Shadowins, that you talk with an attorney before you do that. But I guess, you do have the right to request that trial be set if you'd like.
Thank you, Your Honor. I think it would be improper to plea at this point without said discovery.
Are you asserting that you cannot assess your own guilt or innocence without first reviewing the prosecution's evidence? Such a claim demonstrates a fundamental misunderstanding of how the legal process operates.
Okay, well, then I will just give you a pretrial conference on all your cases, and you should just follow the procedure that the district attorney's office has given you to get that discovery in these cases, okay?
I will do to the best of my impossibilities, clearly stated as a matter of record. And I would encourage the people and the court, please, to look at my filings. I was noticed by the court clerk that Your Honor was in possession of my filings. Again, I didn't get response from the courts or the people. And so I'm just here in good faith. However you wish to proceed, I waive the court.
Okay.
At this time, Ms. Gilbert.
Well, so Mr. Shadowins, the only filing I have in, you submitted, bless you, a number of notices and other documents. They did not have a case number on them, so they appear just simply to be notices that you're of different things. But it certainly did not ask for any relief in those notices. They're all filed in 25T448, but because we didn't know what case it went to. I did notice that at least in some cases that you have filed a notice to dismiss or a motion to dismiss, and I have a difficult time reading your handwriting, so I couldn't address it over the weekend because I just could not read it on my computer. I am going to print them out in the hopes that I can decipher what exactly you're saying, and then I will address your motions to dismiss in writing. I'm perfectly happy to do that. But in the meantime, we are going to give you a pretrial conference date, and you should go to you should follow the procedures that the district attorney gave you in order to obtain discovery in all of your cases. All right, so that pretrial conference date is going to be December 1st at 8:30. December 1st at 8:30 on all your cases, okay?
This video primarily focuses on the judge's review of the multiple cases filed against him. For a complete breakdown, where the judge systematically dismantles his arguments, please refer to the previous video. I will share any follow-up developments as soon as they are released. If you found this video informative, please like it, share your thoughts in the comments, and subscribe with notifications enabled to stay up to date. Happy holidays!